Oh, okay. Mm, mm, mm.
Miss Ramona.
Yes.
Hey, good
Can you
morning,
hear
ma'am.
me?
Yes, ma'am. I got you
Good
checked in.
morning. My audio
Good morning.
is good. I'm gonna hear you.
Your phone's going in and out, ma'am.
All right, the court at this time calls case number 2149753. This is HS Financial Group LLC versus Michael
Trying
Gregory.
to
Excuse me, the matter is before the court
hear
filing of an application for subpoena.
you.
Good morning, Judge. My name is Ed Mall. I'm standing in for Clifford Dovitz on this matter, plaintiff's counsel, and he has scheduled a creditors examination for this morning. It was set at 9:30 of Michael Gregory. And I don't know if Mr. Gregory is here yet.
I'm sorry. The court is calling now.
Can you hear me now?
All right. No one should be speaking at this time. I hear someone, it appears that speaking as a Ramona Williams, you're interrupting the hearing, so I put you on mute. I'll get to your case. When you hear your case called, then respond to the court as I call your case. Thank you, Mr. Mull. I'm looking for Mr. Michael Gregory. Michael Gregory, he's set to be here at 9:30. It's now 9:58. It does appear that Mr. Gregory has not appeared under the order of the subpoena. Accordingly, the court will issue an order to show cause where a defendant has not appeared for the hearing. And counsel, I will sign the order of show cause upon presentment to the court. And you can send that by way of email, or you can send it into the court, and we'll get it right back to you.
Hey, Judge, could you tell me the email I should send that to?
Yes, sir. That's Latifah, LATIFAH.Hunter@36districtcourt.org.
All right, thank you, Judge. And then the court will set a show cause date itself, correct?
That's correct, counsel.
I'm not familiar with your procedure on this point. I was at one time, but I don't know now. Does the show cause have to be personally served, or will that be mailed?
Now, that's a personal service at least 7 days before the hearing.
Okay, I appreciate that. Thank you.
Thank you, counsel.
Okay, bye-bye.
All right, the court now calls case number 2155265. This is Midland Credit Management versus looks like Kalita Thomas. The matter is before the court set on for a hearing on today's date. Your appearance for Midland at this time.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
All right, good morning to you, Ms. Strickhart. Let me see if I have the defendant on this matter. Last name Thomas, first initial K. If you're on the Zoom, please say something at this time, or counsel.
Yes, Kylita Thomas is on the Zoom.
All right, thank you. Good morning to you, Ms. Thomas. I'm not seeing your image anywhere, but I do hear your voice. All right, so today is a date that is set based upon the joining of this matter. I received a responsive pleading or answer to the complaint in this matter. Ms. Strickland, on behalf of Midland, what do you need, if anything, by way of discovery in this matter?
We just asked, Your Honor, for a brief written only discovery. This is a very low balance collection matter, document driven. So we would ask for 45 days discovery, and then enough time after that, perhaps 45 days in filing that, any dispositive motion that may be necessitated.
All right, very well. Ms. Thomas, the other side is asking that the court would follow the process that it normally follows, and that is to allow for a period for the parties to exchange information between each other to determine and to narrow what the issues are in this case. You understand what that process is about, ma'am?
Yes, I do.
Now,
Okay.
all right, I don't have a full file in front of me on this case. So tell me, Madam Counsel, what's the balance that is alleged in this matter?
Your Honor, the principal damage prayed for in the complaint is $1,142.43.
All right. And let me ask you, Ms. Thomas, do you believe that having a discussion with the attorney on the other side might help to resolve this matter?
I don't know if this matter because the amount that they're saying, I lack sufficient knowledge on that. So I'm denying that allegation of that amount.
All
In
right,
which
so-
case, Your Judge, we just ask for the discovery order to be entered.
All right, and
And
of course, you've already asked for that. Excuse me, that's a bit redundant. Now, what I'm getting at here is that it does appear, Ms. Thomas, that you are indicating that you believe that something is owed, but you don't know what the amount is. Is that what you're saying?
I'm saying that not through Midland, through Credit One. Credit One, I contact Credit One months ago, and they told me that on 6/16 that my account was closed and satisfied.
Okay. Like you get something in writing that said that?
No, because I did it over the phone when I talked to them. Sorry, I didn't know. This was way before. I didn't know that I was going to need it until they came after me on 10.
Well, just by way of clarification, Your Honor, the account did go into bad debt status, in which case the original creditor would show it closed and what they call charged off, which means it's written off as a bad debt as to the original creditor, at which time through assignments, my client ultimately owned it. So maybe that helps clarify that element.
Thank you, Mr. Strickland. Yeah, that's the typical course of things, is that someone else owns the debt now, and the previous creditor has written it off, likely sold the debt to someone else. That would be the trajectory of this, and why you would be hearing from Midland regarding this matter. All right.
Okay.
So my thought is that if there is something that you agree might be owed, then it might be worth a discussion to see if you could arrive mutually at a number that might resolve this case. If you were willing to have that discussion, then I would put you in a breakout room to try and resolve this.
Okay. I mean, I can try that. I just know it's not 1,100. I was never given a credit card for that amount.
All right. You know, over time, I'm sure that there is accrual of interest and cost and all that kind of stuff, and that's a part of it. Ms. Strickland, do you have authority to settle this case for something less than the actual amount that's being pled here?
Yes, if it can be paid in a reasonable amount of time, Judge, I have full settlement authority.
Okay.
What is reasonable amount of time?
We can always work on that part of it. You can likely get a reasonable period of time to pay this, and we can talk about that. What I want to do is take a moment here to allow you and Ms. Strickland to just take a moment to talk. I know that you've been waiting already this morning. I want to set you in a break and talk about numbers. Maybe we can exchange an offer. And if that can be worked out, then the court will engage with the parties to try and find a way that this can be paid in a reasonable period of time, if you can arrive at a number. And then just come back into click back into the courtroom. So, Ms. Strickland, I am going to give you access to breakout room number 1. And Ms. Thomas, what device are you on? Because I still don't see you. What name did you come in?
I'm on my smartphone because I went down to the court. I thought I was supposed to appear in court, so I had to hurry up and get on the phone.
Let me stop you. Answer my question. Okay, so your smartphone, that's the first 3 numbers are, what is it? 971, correct?
Correct.
Okay, so I'm sending you to the breakout room. You'll be able to talk with the attorney on the other side. Let's talk numbers, see if you can get this resolved, so that we can find a way to close this out. Come back into the
Okay.
courtroom. There you go, ma'am. There's your notification. All right, thank you for your patience. All the court now calls 21-160-819. This is Grossbeck RX versus City of Detroit. The matter is before the court after the court previously issued a scheduling order in this matter. Your appearance for the city, it's right there for Grossbeck RX, please. All right, I'm looking for someone from the City of Detroit on this matter. All right.
Ms. Olmsted was here, Judge.
All right, we'll recall the matter. We'll recall the matter shortly. Thank you, Madam Reporter. The court now calls case number 21-162-847. This is J.P. Morgan Chase versus Daisy Willingham. The matter is before the court, set on for a final pretrial conference on today's date. The court previously having allowed for a period of discovery in this matter. Your appearance for J.P. Morgan Chase, please.
Good morning, Your Honor. Jim McCarl on behalf of J.P. Morgan Chase.
Your P number, if you will, Mr. McCarroll.
82443.
All right, thank you, counsel. Good morning to you, sir. I'm also looking for Daisy Willingham on this matter. And if you hear, ma'am, say something at this time.
Yes, I'm Daisy Willingham.
All right, Ms. Willingham, good morning to you.
Good
ma'am.
morning.
All right. So I know that I allowed a period of discovery regarding this matter. I did receive Ms. Willingham's answer regarding this, and I know that this has to do with the allegations that there is an outstanding debt in the nature of some $4,300 or so. Is that about the size of this, counsel?
Yes, Your Honor.
So tell me what's the positioning of this case now after discovery? Where are things now, sir? If you will update me, and I'll talk.
Well, Your Honor, we're in the position where the defendant admits that she owes the debt. The problem is an ability to pay. And so I don't know if Your Honor wants to set a trial schedule with a period for dispositive motions, and perhaps we can do away with this with a summary disposition motion, or we go to trial. But at this point, I'm really at a loss as to how to resolve this, because she simply doesn't have the ability to pay.
Ms. Willingham, is that about the size of it? Go ahead, you can talk to me, ma'am.
Yes, the lawyer told me to call for a hardship package, but they didn't know anything about it.
All right. So did you request a hardship package, or?
Yes,
So what's going on with that, Mr. McCarroll?
Your Honor, I'm looking to see, I don't know when she called, but typically we send out the hardship packets. I will say this, though, J.P. Morgan Chase is very, very tight when it comes to hardship determinations. So I don't know that it would have been approved in any event, but I don't know. Let's see. Yeah, she called on November 9th, Your Honor. I don't see. Let's see what happens here. Bear with me, Your Honor. I think the hardship was denied, Your Honor, back in November.
All right. So was that a denial after her application, or they just, this is one of the cases where they don't entertain a hardship package, correct?
Oh, I don't know if they sent one out or not, but it does suggest in the notes that this the request for a hardship was denied.
All right. Thank you, sir. So, ma'am, do you have? I don't want to delve into too many great details, but do you have a source of income? Do you?
I have a pension and Social Security.
Yeah. So, so it's been suggested that you're not really disputing the debt here, but that your challenge is ways that you might be able to resolve. Is that about the size of this?
I don't have the money to pay. Before my husband passed, he was paying paying the bills. Now that he's gone, I don't have that money.
Gotcha. Gotcha. Well, you know, that if an order of settlement was entered in this case, you could express to the court the nature of your hardship, and that hardship would determine what the court will require you to pay. The debt appears to be in excess of $4,000 under a hardship scenario where it appears that you do not have much ability to pay. Your payment in such case could be as low as $75 or $100 a month. I mean, that's one way that you could go about doing it. Setting a payment lower than that range would be difficult because under normal circumstances, a payment on this kind of case would be in the nature of $200 to $250 a month. But if you're dealing with hardship, you're on a pension, you have some Social Security, and that was the only way to subsist, I could probably find a way to set that payment at $75 to $100 a month. Is there any chance that you would be able to make that kind of payment?
I could make the 75, but they told me before that that wouldn't even help on my case.
Well, that would not be their determination. It would be the court's determination based upon your application. And what you're saying to me is that you have very limited resources and you have an inability to pay. Based upon that and based upon the amount that's owed, I'm saying to you that I could set that payment. And, you know, I said $75 to $100. So I would likely set the payment at $80 or $85 a month. If you're willing to, if you believe that you can keep up with that payment, then you could enter into the agreement. I will allow you to make that payment. Make a petition later on to ask the court to increase the payment amount. Then I would have a hearing and evaluate your resources. And if there's no reason to increase it, I wouldn't. If it seems that you have amounts that I should increase it, then I would increase it. But as long as you are living at the level that you're living right now, I don't see a likelihood that it would be increased from the $85.
Okay.
Right. So I think that to the extent that we found an amount, it's not an amount that makes you happy, and I'm sure it doesn't make the other side happy. But given hardship kind of circumstances, the court could make that decision that you could pay it at that level. Now that means, of course, that you'd be paying forever because it's not really covering on stuff the way that it could, but it would at least have you in a position where you're paying something, and there could not be any garnishment of your wages. It could result in garnishment of a non-federal bank account. So, for example, if you got Social Security money in a bank account, they couldn't take that. They couldn't garnish the bank account. But if you got money other than Social Security in a bank account, that could be garnished. If it's not a federal pension, it could be garnished if the funds from a federal pension are in a bank account or something along those lines. So that would be the kind of things that you're looking at. Now, let me just mention one other thing, and I have to go on to some other cases. Now, I'll give you and Mr. Vigardo an opportunity to speak about it. He's already indicated the limits of his authority with his client. But in light of the fact that the court could allow a payment plan of the nature that I described, I'll give you the opportunity to talk. If a motion is filed or a trial is held and the court ultimately determines that it's a debt that you owe, then that's a situation where you have a judgment without any type of payment arrangement. If you have a judgment without any type of payment arrangement, that's like open field. They can come after you every possible way. And so having some control over that makes sense. You understand what I'm saying, Ms. Willingham?
Yes.
All right, so if you will, and you can come back in, but if you will, I'm going to put you in breakout room number 2 to see how you may be able to fashion an agreement. And with that in mind, that the court would cap that payment at $85 a month. And
Okay.
and you could go forward accordingly. So I'm gonna put you in breakout room number 2 to see, to work on the details in light of the things that the court have communicated. So you're receiving a notification from me now to try to get towards that. There you are. All right, the court now calls, trying to see which one. The court now calls case number 12-107029. This is First Resolution Investment versus Ramona Williams. The matter is before the court, set for an objection to a garnishment, set for hearing an objection to a garnishment. First resolution, your appearance at this time.
Good morning, Judge Coleman, Cezanne Barta, P 65425.
Thank you, Mr. Barter. Good morning to you, sir. And I'm looking for Ramona Williams. If you're on the Zoom, say something at this time, Ms. Williams. Ms. Williams? I see a Ramona on my screen. Ms. Williams, if you're hearing me, please say something at this time. Ms. Williams, I see you having some technical difficulties. Are you able to hear me? Looks like your sound is not connected, Ms. Williams. So what I want you to do, if you're hearing me, hang up and dial back in. And when you dial back in, connect your audio.
And if I may, Your Honor, can I just state one thing real quickly?
Sure, Mr. Barter.
Ms. Williams, this is an objection to a tax garnishment. She has had a $125 payment arrangement since 2015, and she's made every single payment since then. We file tax garnishments across the board, and then we reevaluate them. This is one that she's almost, I'm gonna let her, or I want to ask the court to just grant her objection to tax garn. So when she reconnects, you can tell her that. Do I need to stay? Because I have some other hearings.
No, you don't need to stick around. I
Okay.
got you. Appreciate it. I know you want to stay here. You better be here. But no, go ahead and do your other work.
All right. Thank you, sir.
Thank you.
All right.
Have a good day.
You too. Bye.
Ms. Strickland, I'll be right with you, ma'am. All right, Ms. Williams, are you able to hear me? All right, if you're able to hear me, Ms. Williams, your petition is being granted. Your objections to the writ of garnishment on the third party Michigan Department of Treasury, your objections are granted. And the garnishment is released. So if there are any funds there, those funds will be released to you. And we're back on the record regarding Midland versus Thomas. And thank you, Ms. Strickland. Ms. Thomas, are you back? Or did she get stuck in the breakout room? Let's see. Yeah, she's stuck there. Ms. Strickland, you know how to go back and help her to get out of there?
Yes, I had instructed her on how to leave the breakout room, but not leave the meeting.
Well, she seems like she's still there. So
Do you want to I think there's a way for you guys to pull her out.
You didn't have to expose me like that.
Is there anyone in the courtroom who can assist?
Hello?
Aye. Do I have Ms. Williams?
Yes, yes. Can you hear me?
Actually, yeah, Ms. Williams, just hold on a second. I'm looking for Ms. Thomas. Just 1 second, Ms. Williams. I'll be
Okay.
right with you. I'm looking for Ms. Thomas.
Thank you.
Just 1 second. I don't know how to get her out of here, council. Why don't you go ahead and give me an update on.
Yes, we were able to resolve, Judge. I can place it on the record and perhaps submit it under 7-day.
Go right ahead, council.
Okay, the parties agreed to a consent judgment. The condition on it is that the defendant will be permitted to satisfy the judgment for $936 by paying $80 monthly, beginning March 28th of this year and the 28th of each month thereafter. If the defendant obviously does not make payments as agreed, the judgment of principal damage $1,142.43 as prayed for in the complaint would be enforceable, as well as the filing fee of $55, the service fee of $52.72, totaling $107.72 in costs. Plaintiffs would not be seeking any attorney fee, for a total of judgment entering in the event of breach of $1,250.15. So the judgment would enter with this special condition, allowing her to satisfy it at a reduced amount as long as she does comply with the terms. And I can submit that under 7-day, Your Honor, either by email on Monday or through the mail.
I will allow you to submit it under the 7-day order and certainly at the side, and the court will sign the order upon the expiration of that time. The court is taking special effort here because Ms. Thomas is stuck in the breakout room. If she makes it back into the courtroom, I'll go over the terms with her again as documented.
And did you say email, Judge, or mailed?
Yeah, go ahead and send it by email, counsel.
Okay.
That's going to be Latifah, LATIFAH,
Mhm.
.hunter at
Mhm.
36districtcourt.org.
Judge, do you mind if I read that back to you just to make sure?
Absolutely.
I've got LATIFAAH at Hunter. No, I'm sorry, Latifah.hunter@36districtcourt.org.
That's correct. And you got that, at 36TH, correct?
Yes, Your Honor, and I would like to submit that on Monday, if that's pleasing to the court by email.
That's fine. That's great.
Okay, thank you so much, Your Honor.
Thank you,
Have a
counsel. Thank you. Tom.
Have a wonderful day.
All right, you too. And Ms. Willingham, I see that you're back. I'm waiting for the attorney to make his way back in the courtroom. Just 1 second. Oh, there he is. All right.
Okay.
Okay.
All right, again, welcome back, Counsel, Mr. McGarrell, and Ms. Willingham is back in the courtroom as well. I sent you to the breakout room to have some discussions. Sir, why don't you update me?
Yeah, we discussed what you were proposing, and I believe Ms. Willingham is willing to agree to it. The only point of clarification I want to make is you mentioned something about the balance being over $4,000. At least that's what I understood, and it is. It's $18,261.75.
Oh, well, I'm glad that you, that's an important point. I was looking at a billing. I am now looking at the, I'm not looking at the complaint, and the complaint does plead for $18,261.75. So that's a big amount. Again, with you not having a whole lot of resources, the court still, the payment would be set miserably low. But again, the plaintiff would have the right to proceed with other attempts at collection, so on and so forth. So, Mr. McArdle, go ahead and talk to me, what happened in the breakout room.
Well, Your Honor, I told the defendant that this was probably the best solution given her limited resources, and asked her if she was willing to proceed under your proposal, and she said she was.
Yeah, that is I think under all of the circumstances, ma'am, I do think that that is the most reasonable way to go forward. Unless you have something whereby you can prove that this is not your debt. If you don't have anything to prove that, then there's not another way to do this. Of course, you always have the alternatives of filing bankruptcy and things like that, but you know, short of something like that, being able to control this with a payment of $85 a month is the most reasonable thing that you can do here. And I'm recommending that. I'm going on the fact that you told me about the loss of your husband, who was a primary provider, and that you have limited resources yourself based upon your retirement and Social Security. So this is an extraordinary, it would have been extraordinary even at $4,000 or $5,000 to have a payment at $85 a month. At $18,000, that's
amazing.
You know, that's huge.
Yes,
You want to go forward with that, ma'am?
yes, yes, sir.
All right. So what I'm gonna do is I'm going to have the attorney to send an order to me. It's going to be an order of judgment, and it's going to have payment allowed by the court at $85 a month, and that will be the order that resolves this case.
Thank you, Your Honor.
All right,
Thank you, Your Honor.
That's acceptable to you. Is that correct?
Yes.
So I'm going to sign it, and you'll get a copy of it, and you'll know that your obligation will be to pay the $85 a month towards that. Now, you probably want to start that payment in February, so I'll make that first payment due on the 11th of February. That makes sense to you?
Yes.
Okay, and so you don't have to write the date down, it'll be in the document that you receive. February the 11th is the first day. And so the second Friday of each month is the time that you want to make sure that payment is in. So I started it the second Friday in February. So basically you want to make sure that you make the payment by the second Friday of each month.
Okay, I gotta make one for January.
No,
It's
ma'am.
February. It's February.
February 11th will be your first one.
Okay,
But no,
All right.
so you'll be making a payment to the court or to?
okay, do I make a payment to the court?
The document that you're going to receive, the judgment document, is going to have the location where you make the payment to. It's going to be, that's going to be to the attorney's office. He's going to provide information as to exactly where the payment should come to.
Thank you so much.
Mr. McArdle, anything at this time, sir?
Your Honor, how do you want me to submit the order to Chambers? Is there an email I can submit it to?
Yes, I'm going to give you the email address, and the acknowledgement of the order is already set forth on this record, so I'm prepared to sign it under the terms that have been set forth. The email address is Latifah, LATIFA.Hunter@36districtcourt.org.
Is that 36th, the ordinal or the cardinal?
3636PH.org.
Thank you.
All right. And
Thank you, Your Honor.
All right, thank you, Councilman. Ms. Willingham, once that order is signed, a copy will be sent to you with the exact things that we talked about here today.
Thank you.
Thank you, Judge.
I do wish you well. All the best to you, ma'am, and thank you, Council. The best of the new year to both of you.
Thank you, Judge.
Thanks again, Judge.
court now calls case number 21-161839. This is Coleman L. Potts versus Riverfront Towers Apartments. The matter is before the court, set on for a pretrial conference. Your appearance for the plaintiff at this time, please. Do I have Mr. Potts or anyone representing Mr. Potts at this time? For the defendant Riverfront, do I have anyone from Riverfront Apartments? We'll recall that matter. All right, I see Miss Williams back. Miss Williams, I called your case previously, is that correct?
I'm not certain. I was having technical difficulties. Can you hear me now?
Yes, I can.
Yeah, that was Barter's case,
fantastic.
remember? Barter.
They granted it for her.
Oh, yeah, Ms. Williams, your petition was granted. The other party agreed, so the garnishment is released. They said that you are under a payment plan and that you have not missed a payment and you kept up with it for the entire time. And so they've elected to back away from the garnishment. So I've signed an order granting your petition and releasing the garnishment.
Yes.
You'll get that.
Thank you so much.
Absolutely.
All right. Have a blessed one.
Likewise to you. All right. All the best.
Thank you. Bye-bye. Thank you, Jesus. Whew.
Mr. Viscotti, looks like you're in another courtroom. Well, when you get a moment, let me know which. All right, Mr. Viscotti.
Your Honor, I apologize. I'm finishing up with Judge Garrett. I'll be with you in about a minute and a half.
So you have your serial number. Your next court date is March the 14th at 9:25.
Thank you for your patience, Judge. I'm available whenever you need me.
Thank you, counsel. Which case do you have, sir?
Your Honor, I have the defendant, Riverfront Towers Apartments, in the Coleman Potts versus Riverfront Towers case.
All right, gotcha. I did call that one with the suffix 1839, and I did get a response from the plaintiff in that matter. Let me have your appearance formally on the Potts versus River Towers apartments.
Robert Visconti, P61756, on behalf of the defendant.
Thank you, counsel. So have you spoken with the other side? Because I'm surprised that nobody's here.
Yeah, I'm surprised nobody's here too. I have not. To be honest with you, we're spread so thin with coverage on all of our landlord tenant stuff that this one kind of got dropped on me, and I'm working from home with COVID. So I have not had any direct contact with Attorney Hill or Attorney Potts. My plan today was just to ask the court for dates and discovery. I don't know if perhaps the court would want to reschedule the pretrial.
Yeah, let me set it out just a couple of weeks and let's see if we can get everybody here.
Sure.
And then we set some type of schedule. All right, so.
You said a couple of weeks or what?
Yeah.
So towards the end of the month,
Yes.
the 24th.
February 24th.
2/24?
1/24.
1/24.
Yes, sir. And I'll go ahead and keep that time at 10 a.m. 1/24 at 10 a.m.
Very good, Judge. Thank you so much.
All right, we'll address these matters at that time.
Have a good day.
Yes, sir. Everyone?
I'm here. We're still on YouTube.
Yes, I was trying to see if this Armstead was coming back.
Oh. Yeah, she didn't know.
No, she didn't see, said she was gonna wait. She was here, one of the first people, but then I don't know what
Right.
happened.
Mhm. Hmm. Oh, oh, oh.
This one, I thought this one was for this, is it for Daisy Willingham, the older lady, Judge? This part, is this what it's like? Willingham, I think so.
Willingham is the older.
Yeah, that's her payment.
That's not.
Yeah, that's not, this,
Yeah, that's, you're waiting on the email of the portal.
I'll go for
That's
this.
just the details on.
Oh, these details for the $80 is for the older lady, right?
And $85 is for the older.
Okay, $85, okay,
Yeah.
then $80, okay. That's that. Is it in your box?
It's like right there. It's that another one.
My elder died last night.
Oh,